I sometimes think that too many cases are described as seminal or as landmark, but Salomon and Salomon is the real thing. It is a striking example of the central role which the law can play in our economic and commercial lives, and remains undoubted authority well over a century after it was decided. The company, as we know it today, was created by a number of statutes in the 1840s and 1850s, and included the intuitively slightly odd idea that it had a separate legal personality from its members, its owners. Even so, it was only in Salomon and Salomon in 1896 that the courts fully recognized the implications and possibilities of this doctrine. Mr. Salomon was a prosperous London leather merchant who decided to convert his business into a limited company. Salomon and Company Limited was formed and purchased the leather business from Mr. Salomon for the probably excessive price of £39,000. Some of the price was paid in cash, some in shares, and the remainder was owed to Mr. Salomon and secured by a charge over the company's assets. Of the 20,007 shares which were issued, 20,001 were allotted to Mr. Salomon, and one each was allotted to his wife and 5 children, but they held them on Mr. Salomon's behalf, so that he was effectively the sole owner of the company. Needless to say, the company ran into financial problems, and a liquidator was appointed. There was no money left to pay unsecured creditors. The judge and the Court of Appeal held that the incorporation of the company was not compatible with the true purpose of the Companies Act, but was rather a sham which left Mr. Salomon as the real proprietor of the business, while the company was nothing more than his agent or his trustee. He was therefore liable to indemnify the company in relation to its trading liabilities. On further appeal, the House of Lords unanimously held that the lower courts had been wrong. The law, at least in 1896, required only that a company had 7 members, each holding at least 1 share. It did not also require them to be independent shareholders. The company was therefore validly formed, with the consequence that it had a separate legal personality, which meant that it, not Mr. Salomon, owned the business. That, the lordships held, was the end of the inquiry. The House of Lords felt rather sorry for the now penniless Mr. Salomon, and thought that he'd been roughly treated in the courts below, where it had been insinuated that the purchase price of his business had been deliberately inflated, or that there was something underhand about the incorporation itself. The House of Lords took the opposite view. He had been honest, but unlucky. Lord Macnaghten recognised that the business might be entirely the same after incorporation as before, with the same managers and the same people receiving the profits, but the company was not the agent of the shareholders or their trustee. Because of its separate legal personality, the company had different rights and obligations, and crucially, its owners were not liable for its debts. This was, and remains true, of one-man or one-woman companies, as much as of companies with hundreds or thousands of shareholders, and vastly increases the possibilities of the company as a vehicle for commercial enterprise. The effect of the decision in Salomon has sometimes been controversial, and as with so many things, the attitude of the courts to lifting or to piercing the corporate veil, in other words, disregarding its separate legal personality, has ebbed and flowed over the decades. There are, of course, a range of ways, both inside and outside insolvency, that others can be made legally liable in respect to the activities of a company. But, as the Supreme Court recognised in Preston Petrodel in 2013, these are almost always the result of the application of other legal principles to the corporate context. Otherwise, except in very rare cases, separate legal personality is sacrosanct, and the principle in Salomon endures, undiminished by the years.